Hey everyone, Noah here. A single name, spoken with judicial clarity, can stop time. It can strip the air from a room and suspend every heartbeat within it. That is what transpired moments ago in a federal courtroom in Washington, D.C. For 11 seconds, the machinery of justice ground to a halt. No rustle of a legal pad, no click of a pen. Even the stenographer's flying fingers froze mid-stroke. And in the center of this sudden vacuum sat Donald J. Trump, motionless, the color draining from his face as if someone had pulled a plug. This is the moment a shadow from the past steps into the light, not as a character witness, but as the prosecution's star. This is the moment the witness you never truly believed would turn, does. What I'm about to detail occurred just 38 minutes ago, at 10:23 a.m. Eastern Time, in the United States District Court for the District of Columbia. Judge Patricia Whitfield was presiding over a standard pretrial hearing, navigating procedural formalities, when she addressed a new filing. "The government has notified the court and defense counsel," she announced, her tone neutral and procedural, "that they intend to call." She then read the name. The effect was instantaneous and electric. Trump's head whipped toward his lead attorney, Richard Kleen, with such force that the groan of his leather chair echoed in the silent gallery. Kleen himself, a figure known for his unflappable courtroom demeanor, went visibly pale. A junior member of the defense team, 2 seats away, fumbled his pen, the sharp clatter against the floor sounding like a gunshot in the stillness. And then, nothing. Silence. It stretched. 8 seconds, 9, 10, 11, a heavy, breathless void that swallowed the entire chamber. Judge Whitfield, a veteran of 19 years on the federal bench who has witnessed every manner of courtroom drama, waited. Even she appeared momentarily arrested by the sheer, palpable shock that had gripped the room. Finally, Kleen found his voice. He rose, his usually commanding baritone thin and strained. "Your Honor, the defense requests an immediate recess." Judge Whitfield granted 15 minutes. The moment she departed the bench, Trump was upon Kleen, leaning in, his words a rapid, urgent torrent. Court observers could not hear the content, but the form was unmistakable. Sharp, staccato hand gestures, an unblinking intensity in his eyes, a head shaking in a relentless, disbelieving rhythm. When the hearing reconvened, Kleen moved formally to exclude the witness entirely, citing inadequate notice, questions of relevance, and assertions of privilege. Judge Whitfield denied the motion. She noted the prosecution had adhered to proper procedure and stated that the witness's testimony appeared, prima facie, directly relevant to the charges at hand. For the remaining 42 minutes of the proceeding, Trump sat in a state of eerie catalepsy. The familiar, restless energy, the shifting in his seat, the whispering to aides, was entirely absent. He was a statue, his gaze fixed on some middle distance, a man who had just been shown the trapdoor beneath his feet. Now, let's reveal the identity that has triggered this seismic shift. While the name remains technically sealed in the court's confidential filing, I have confirmed it through 3 independent and well-placed sources. 2 individuals present in the courtroom who viewed the unsealed witness list, and 1 legal professional with direct insight into the prosecution's strategic planning. All 3 sources corroborate the same identity. The witness is Cassidy Hutchinson. Yes, the same Cassidy Hutchinson who served as special assistant to Trump's chief of staff, Mark Meadows, the same individual who delivered unforgettable testimony before the January 6th Select Committee, the same young woman who occupied a ringside seat to the most critical and most clandestine conversations in Trump's orbit during the fraught period following the 2020 election. But here's the revelation that has remained buried until this morning. Hutchinson has not merely testified before Congress. She has been a cooperating witness for federal prosecutors for 14 consecutive months. 14 months of grand jury testimony, 14 months of evidence provision, 14 months of detailing conversations and events that cut to the very heart of alleged criminal conduct. For those who need a refresher on her pivotal role, Hutchinson was not some peripheral intern. She was Mark Meadows' right hand, his principal aide. This position placed her in the sanctum, the meetings where post-election strategy was formulated, on calls with state officials, in briefings where attorneys outlined legal options and, critically, legal perils. She was a silent witness to dialogues intended to remain forever private. At just 28 years old, in those chaotic weeks, she possessed an access granted to few. She was a meticulous note-taker. She possessed a near-photographic recall for detail, a fact she demonstrated during her congressional testimony. That testimony was damaging enough. It contradicted Trump's public narratives, established a timeline that suggested calculation over chaos, and revealed a level of knowledge that severely undermines claims of innocent intent. But that public appearance, we now know, was merely the opening act. Sources indicate that following her committee testimony, federal prosecutors approached Hutchinson with a proposal for deeper cooperation. They sought her testimony before secret grand juries. They asked for the granular, unvarnished details that are the lifeblood of a criminal indictment but are often too sensitive for a televised hearing. They needed her to help construct the architecture of their case. And she agreed. For over a year, she has been in a closed-door partnership with prosecutors, guiding them through the labyrinth of conversations she witnessed, providing context to cryptic communications, and mapping the intricate chain of knowledge within Trump's inner circle. She has testified, sources confirm, before multiple grand juries, one investigating the January 6th obstruction of Congress, another examining the handling of classified documents at Mar-a-Lago, a third probing attempts to interfere with state electoral certifications. She is not a witness to a single isolated act. She is a witness to a pattern of conduct across multiple potential criminal violations. Let's analyze what makes Cassidy Hutchinson a uniquely devastating witness. First, her credibility is a fortress. She is a young, lifelong Republican who served the Trump administration with loyalty. She had every personal and professional incentive to protect the world she inhabited. Initially, sources say, she attempted to do precisely that, giving cautious, limited testimony to the January 6th committee through an attorney with ties to Trump's orbit. But a profound pivot occurred. According to those familiar with her journey, Hutchinson grew increasingly disturbed by what she perceived as a coordinated campaign to manipulate her testimony and intimidate her. She fired her original counsel, retained an independent legal team, and made the consequential decision to tell the whole truth. This evolution, from a protective insider to a full cooperator, makes her narrative uniquely powerful. She is not a partisan antagonist, she is a disillusioned loyalist, and her credibility is rooted in that very journey. Second, she can testify to mens rea, criminal intent. The cornerstone of Trump's defense across all cases is a claim of sincere belief, that he genuinely thought the election was stolen, that he legitimately believed he could retain classified documents, that he was acting on advice of counsel. Hutchinson was present in meetings where Trump's own attorneys told him his claims were baseless, where they warned certain actions were illegal, where advisors explicitly stated strategies constituted obstruction. She can recount Trump's responses to these warnings. What did he say when his lawyers told him no? How did he react when presented with facts that obliterated his public statements? This testimony strikes directly at the core issue of knowledge and intent. It can demonstrate not just questionable action, but a knowing, willful violation of the law. Third, she is armed with contemporaneous documentation. As Meadows' assistant, note-taking was part of her official duties. But sources indicate her personal notes went far beyond mere scheduling. She documented conversations that troubled her, preserving real-time records of events she sensed might one day hold significance. When she began cooperating, she turned over hundreds of pages of these handwritten notes, a dated, timed, verbatim log from the epicenter. This is not reconstructed memory from years later. It is a contemporaneous diary, providing irrefutable corroboration. Fourth, and most critically, she is the connective tissue between multiple cases. Hutchinson is the common thread. On January 6th, she can describe planning meetings, discussions of potential violence, and Trump's resistance to deploying the National Guard. On classified documents, she can recall conversations at Mar-a-Lago about the materials, instances where Trump showed them to visitors, and directives about defying National Archives requests. On election interference, she can detail calls with state officials and Trump's demands when they resisted. She allows prosecutors to weave separate strands of evidence into a single damning tapestry, demonstrating a repeated willingness to subvert legal norms for personal ends. This morning's revelation fundamentally rewrites the legal battle. Trump's team knew Hutchinson was a problematic witness from her committee testimony. They have spent months preemptively attempting to dismantle her credibility, labeling her a fabulist or a pawn. But they were operating in the dark about her 14-month clandestine partnership with the special counsel's office. They knew nothing of the grand jury appearances, the expanded evidence, the testimony refined under prosecutorial scrutiny, the landscape has irrevocably shifted. Trump's attorneys must now prepare to cross-examine a witness who has been stress-tested over countless hours with the prosecution, whose account has been honed and challenged in the secretive grand jury room. Furthermore, Hutchinson's cooperation likely served as a roadmap, leading prosecutors to other evidence and emboldening other potential witnesses. Attacking her too viciously risks alienating a jury who may see a young woman standing up to immense pressure. Failing to challenge her effectively, however, seeds the field, allowing her to single-handedly establish the intent, knowledge, and pattern required for conviction. Sources say this precise, agonizing dilemma consumed Trump's legal team during that frantic 15-minute recess. In the immediate aftermath, expect a barrage of defensive motions. Trump's lawyers will seek to limit Hutchinson's testimony, invoking executive privilege, attorney-client confidentiality, and hearsay objections. Prosecutors will counter that privilege cannot shield criminal conduct, that Hutchinson's mere presence in meetings does not cloak her in attorney-client privilege, and that her notes qualify as admissible business records and statements against interest. Judge Whitfield will rule on these matters, but her swift denial of the motion to exclude Hutchinson entirely signals she believes the witness possesses substantial, admissible testimony. We can anticipate Hutchinson taking the stand within the next 2 to 4 weeks. When she does, sources suggest her testimony will be exhaustive, spanning multiple days. Prosecutors plan to use her as a guide, walking the jury chronologically through the post-election period, using her meticulous notes as exhibits to authenticate a narrative of escalating, deliberate pressure on the pillars of democracy. Politically, this is a fault line. Republican defenses that dismissed her congressional testimony as partisan theater will crumble when that same testimony is delivered under oath in a criminal trial, backed by a contemporaneous paper trail. Hutchinson is not a Democratic operative. She is a conservative former insider. This makes the reflexive witch hunt deflection ring hollow. Several GOP lawmakers have already retreated to cautious statements about awaiting the evidence, while others have fallen into a telling silence. Perhaps most significantly, Hutchinson's public step onto the witness list may have a catalytic effect. Sources indicate at least 2 other former administration officials, previously hesitant, have now initiated quiet discussions about potential cooperation. The dam of loyalty, already cracked, may be on the verge of breaking. Observing Trump's reaction today was profoundly instructive. When Judge Whitfield read the name, his initial expression was not one of anger, but of profound, unadulterated shock. That shock, observers noted, rapidly curdled into something they identified as genuine fear. That fear is a message in itself. It suggests Trump knows, with visceral certainty, exactly what Cassidy Hutchinson heard and saw. His dread is likely not that she will lie, but that she will tell the unvarnished truth with the full, unforgiving force of the law behind her. In the hours since the hearing, Trump's characteristic social media fury has been conspicuously absent. No posts attacking Hutchinson, no claims of a hoax. This silence is deafening. It may indicate his attorneys have warned him that any public commentary could be construed as witness intimidation, or it may reflect his own grim understanding that amplifying her name only magnifies his peril. This quiet will not last. His compulsion to counterattack is too deeply ingrained, but any future assaults will be microscopically scrutinized by prosecutors and the judge, potentially creating new legal vulnerabilities. Here is what to monitor in the coming days. Strategic leaks. Details of Hutchinson's grand jury testimony may emerge, offering a preview of the prosecution's case. The domino effect. Watch for signs of other insiders finding courage in Hutchinson's path. Defense posture. How will Trump's team attempt to undermine her without appearing brutish before a jury? Motions to delay. The defense will likely argue they need substantial time to prepare for this new central witness. Judge Whitfield's tolerance for delay will be tested. Tomorrow's hearing will be dominated by legal skirmishing over Hutchinson. But based on Judge Whitfield's stance today, the jury will likely hear a substantial portion of her account. And what they will hear is the testimony of an insider, a once loyal aide who kept a record, who remembers the warnings that were ignored, the legal lines that were crossed, and the conscious choices that were made. She can articulate the precise moment when political grievance transformed into potentially criminal conspiracy. What transpired at 10:23 a.m. was more than a procedural update. It was the moment a 14-month shadow operation stepped into the light. It was the moment a witness Trump believed he had already survived was unveiled as the beating heart of the criminal case against him. His frozen stillness, the blood draining from his face, was the silent, unmistakable acknowledgement of a peril he now fully comprehends. In the days ahead, as Hutchinson's testimony approaches, Donald Trump will confront a stark reality. Sometimes the most dangerous witness isn't the enemy at the gate. It's the one who was once trusted to guard the door and who has now decided to unlock it for the jury.